Presidential pardon powers are plenary. That's the fancy legal term. It basically translates as untouchable, unreviewable. Presidents, therefore, discuss these powers cautiously. President Trump tried to be cautious today, but also, since he knows a thing or two about exercising these powers, left a glaring non-answer hanging over the politically explosive Jeffrey Epstein matter. Trump refused, given full opportunity to do so, he refused to rule out a pardon for Ghislaine Maxwell, Epstein's accomplice now serving a 20-year sentence for sex trafficking. Trump said nothing specific about Maxwell's fate, but the vagueness he left in the air muddied the waters, intentionally or accidentally, around a second day of meetings Deputy Attorney General and former Trump personal attorney Todd Blanche had with Maxwell in Tallahassee today. These talks occurred amid persistent calls from Trump's MAGA political base and elsewhere for more transparency and possibly more prosecutorial zeal in the direction of other, as yet unidentified and unprosecuted Epstein associates. How a pardon for Maxwell would address this growing political firestorm, one sufficiently intense, we should remind ourselves, to paralyze the House of Representatives earlier this week, beggars the imagination. What Maxwell could say of value also mystifies, since she continues to contest her prosecution and has expressed no remorse. We will talk to a former federal prosecutor about any new judgments the Justice Department might make about Maxwell's incarceration and also the rules that limit that latitude. But first, we start with our Justice Department correspondent, Scott MacFarlane. Scott, I want to play for you what the president was asked and what he said today about all this. Let's listen.
Would you consider a pardon or a commutation for Ghislaine Maxwell if
It's something I haven't thought about. It's really something. It's something I'm allowed to do it, but it's something I have not thought about.
Pick us up on what happened today and what we have been able to glean from this second day of meetings.
The only person talking about what happened inside that courthouse meeting room is the defense attorney for Ghislaine Maxwell, a man named David Marcus, who is acquainted professionally with Todd Blanche, the deputy U.S. Attorney General. But he's not specifically detailing the questions, the answers, or what transpired. He's saying that there were full questions and full answers, no Fifth Amendment invocations, no equivocating by Maxwell, that she was truthful, and that there's no offer on the table for her to accept or reject for sitting down and doing the talks. But what the president said today on the White House South Lawn has infused this criticism or cynicism that there's some type of quid pro quo going on here. And one former Department of Justice official said she's concerned that there's some type of trade-off being made for this interview with Ghislaine Maxwell.
And what's interesting about this, Scott, just to remind our audience, Ghislaine Maxwell, as I remember, and correct me if I'm wrong, did not testify before a grand jury, did not testify in her own defense, has not been a testifying figure in her own criminal prosecution.
Her representatives have said that she has more to say, she has more to tell, and that she was happy to speak with the Deputy U.S. Attorney General and unburden herself of whatever other materials she wants to share. But it's a rather large caveat here. She has a history of being untruthful. She has a history of trying to mislead investigators. And what's more, her credibility is in question, considering she is still facing 12 more years this month in federal prison. And anybody facing those prospects would certainly be looking for some leniency.
And even those members of Congress, Republican and Democrat, who've called for more transparency in this matter, have raised doubts about whatever Ghislaine Maxwell might be telling the Justice Department or anyone else about this case.
Those who've been fueling this fire, alleging that there's some grand cover-up by the federal government, do not seem to be satisfied by the prospect of Ghislaine Maxwell sitting down and talking, or this request for grand jury transcripts to be released, thinking there's not a lot of meat on those bones either. It's hard to see right now the political calculus that cools off the controversy through a Ghislaine Maxwell interview, and most certainly through leniency for somebody who was a convicted co-conspirator of a sex trafficker of little girls.
Scott MacFarlane, as always, thank you so very much. Former federal prosecutor Mitchell Epner joins me now from the Broadcast Center in New York. Mitchell, it's great to have you with us. Thanks for joining us. I'm not an expert on these matters, but I've done a fair amount of reading, and I came across something called Rule 35 in the Justice Department procedures, in which the Justice Department can review a sentence for someone federally prosecuted, but there are specific rules and limitations about what can be done in those cases. Can you help my audience understand that?
Thank you for having me, Major, and you have it exactly right. Rule 35 allows the government to go back to the court and seek a resentencing within 1 year of the original sentence on the basis of substantial assistance to further prosecutions. We're well past 1 year since Ghislaine Maxwell was sentenced. So the discretion that's available to the DOJ and the court is very, very limited here. There are a couple of loopholes. I do not think that this conceivably fits in them, which means that the only way that I could see that Ghislaine Maxwell could get any help from anyone in the federal government would come from 1600 Pennsylvania Avenue and the desk of Donald Trump.
Mitchell, how do you regard this effort to spend 2 days with Ghislaine Maxwell at the Deputy Attorney General level?
It's bizarre. I've been in and around federal prosecutions for over 30 years as a criminal defense attorney and also as a federal prosecutor who led sex trafficking prosecutions. I can tell you that I've never seen a case where the Deputy Attorney General was the person interviewing a potential cooperator. I've never seen the DOJ announce in advance that that they would be interviewing a potential cooperator. I've never seen a former defense counsel for one of the potential targets of the investigation, Todd Blanche here, with regard to Donald Trump, be the person who was conducting that interview. I've never seen any of this. It is completely outside of standard operating procedure at the Department of Justice.
And when people talk about the Epstein files and what is in the possession of the Justice Department, do you have any insight on how we should think about that?
So there was an enormous investigation. Imagine that as being a mountain. Then there was what was presented in front of the grand jury. Imagine that being an outcropping on the mountain. And then there was the testimony that was given to the grand jury. Imagine that being a rock on the outcropping on the huge mountain. And what's bizarre here is that the DOJ is going to court to seek permission to give the tiny piece of information, the testimony in front of the grand jury, which they need court permission to do. But the stuff that they could hand over by a snap of the fingers, the rest of the investigation, they're saying, no, we're not going to make any of that available. As I said before, this is truly unusual. And the last thing that I want to add is Ghislaine Maxwell is under indictment for perjury in the civil case, criminal prosecution civil case, for what she said about Jeffrey Epstein. So she hasn't gone on record in the criminal case. She did go on record in the civil case, and it was so egregious that she got indicted for it.
Mitchell Epner, that is valuable perspective on all fronts. I appreciate your time very much, sir. Thank you so much for joining me.
Thank you for having me.